at Stewart Hospitals. The corporization.
A little bit closer. A little bit closer.
Okay. Thank you, Senator. Thank you. Thank you, Senator Sanders, and members of this committee. My name's Ellen McInnes. I'm a nurse at St. Elizabeth's Medical Center in Boston. I've been there 26 years. For the first 12 years I worked at St. Elizabeth's, we were operated by the Archdiocese of Boston. And then Cerberus Capital came along, Stewart came along, and it's been downhill since then. We have 2,800 Massachusetts Nurses Association nurses and healthcare professionals working at Stewart Hospitals. I'm proud and honored to be representing them today. We hope that we can provide a unique perspective on this issue because we are the front line providers. We provide more than 90% of the care delivered at Stewart Hospitals. The corporization and commodification of healthcare is the guiding ethos of Stewart. It's the one and only priority. And it has led to horrific suffering and harm to our patients, the people who take care of our patients, and our communities. The immediate and most debilitating impact of the ownership of Stewart was the Stewart's tendency to understaff units whenever and wherever they can. I spent 20 years working in the emergency department at St. Elizabeth's, and I can tell you we always struggled to have enough staff, enough equipment, enough supplies to keep our patients safe. Probably one of the biggest impacts is after a patient is admitted to the hospital, they end up sitting in the emergency department for hours to sometimes a couple of days because the units where they should be admitted and safely cared for are not staffed. This chronic understaffing has resulted in preventable harm and even death. The Boston Globe just ran a front-page expose highlighting some of the tragic consequences at Stewart Hospitals. This included 2 patients at Holy Family Hospital in Methuen who died in the emergency department because they weren't immediately assessed and they weren't monitored, and that relates directly to severe understaffing of that department. At Good Samaritan, 2 patients died after spending hours in a significantly understaffed emergency department. One 81-year-old gentleman came in for chemotherapy for his pancreatic cancer, and by the time staff got to him, he was dead. There were 95 patients in that emergency department on that shift, and only 11 nurses. It is absurd to think that 11 nurses can care for that number of patients. At another Stewart Hospital, sadly enough, a 28-year-old gentleman came in. He was in an acute mental health crisis. He was placed in restraints for his own safety, and there was nobody available to closely monitor him, which is what statute provides for. And when he went into distress, nobody was there to rescue him, and he's dead. All of these were preventable. We also have seen Stewart fail to provide the supplies and the equipment that we need. Either the supplies don't come through the front door because we're on a credit hold and nobody will bring them to us. Also, our equipment it's not properly maintained. We have IV pumps and computers with battery lives of 7 to 10 seconds because the maintenance just hasn't been done. During my time in the emergency department, I worked nights. There were nights that we didn't have any Similac or Pedialyte or even diapers. I can think of 2 separate occasions where staff went out in the middle of the night to a 24-hour store to get those supplies. Also, we frequently didn't have food, kitchens locked up. And I personally have given my dinner, my meals to patients, and staff has chipped in and sent out and had food brought in for patients. Sadly enough, sometimes babies die, newborn babies die, and the practice is to place the baby's remains in a bereavement box and take it to the morgue. Stewart didn't pay the vendor, and there weren't any bereavement boxes. And nurses were forced to put babies' remains in cardboard shipping boxes. These nurses put their own money together and went to Amazon and brought the bereavement boxes. Gosh, there's so much more to say. Probably the most tragic and what finally blew the lid off all this was the death of a 39-year-old woman who came to the hospital, had an absolutely normal childbirth, was bleeding. She may have been saved by a device known as an embolism coil. There weren't any in the hospital. There hadn't been any in the hospital for weeks. They had been repossessed by the vendor. She died. Stewart has also caused the closure of Quincy Medical Center. I grew up in Quincy. This was very close to my heart. And now Neshoba and Kearney Hospital. Kearney Hospital sees more than 30,000 patients a year. Boston EMS takes 6,000 patients a year to Kearney Hospital. Where are they going to go? We don't have the capacity in Boston for this. I know we have a lot of hospitals. We also have a lot of patients. And just to be clear, we need not to let this happen again. And thank you for coming together. And it's my sincerest hope that you can put an end to this. Thank you.
Thank you very much. Ms. Spraken.
That was sobering.
I've watched that a lot of times. It's always hard for me to get through, but I love the state. We can't let this happen here. And I think that the concerns that we have about this bill, we have to go through them. They're good concerns. We can't let this happen here. And I'm happy to be wrong about whether or not this can happen here. I strongly believe that it can, if we don't pass legislation to make it clear that a lot of the actions there, reducing staffing, closing hospitals, Massachusetts thought they had this nailed, and they did not. And our statutes are weaker than Massachusetts were. So I really think we need to get this right, and I think this is critical for the state. Happy to take questions, and thank you for bearing with the technology, but hopefully I really wanted you to hear from someone who was directly impacted by this and was a frontline worker in this space, because you've heard a lot of people who have flown at a higher level. It's really important to hear from providers. Thank you.
Thank you. And the technology challenges were well worth it. So thank you. Alan?
Just curiosity.
Yep.
Some of these deaths that she talked about with liability,
Yeah.
does this go back on the private equity stewards, or does this go to the hospital, or where does the liability stand?
It's a good question. I know I believe there are lawsuits pending. I don't know if they've been resolved. I will say, not knowing the specifics in general, a lot of the obligations and liability remain with the hospital or the healthcare entity. And there's been very few examples of private equity firms being held to account for these types of things. The CEO of Steward did not even show to this hearing, to give you a perspective. And oftentimes we don't necessarily know what's happening until it's too late. I mean, I think the lack of transparency in this area, speaking of, I think there's a lot of consensus, there needs to be more transparency because we can't regulate something we don't understand. Or it's very difficult to do that well. And this bill would really take a lot of important steps to increasing oversight and transparency so we really understand what we're dealing with. Because these things are very complicated. I still have to reread and leverage buyout structures myself, and I've been doing this for years. I still have to understand and restudy them. So complicated, but it's a great question.
Any questions for Sam? Woody?
Yes, for the record, I did sign on to that bill, okay? But I do have some concerns
Yeah.
about some of the things that you've mentioned.
Mhm.
You talk about we're currently in multiple crises of affordability, access, and solvency, and I don't disagree with some of those things.
Sure.
But this bill does not address those issues. And quite honestly, I don't know how to address them, but I don't think this bill addresses that. I am concerned with the Green Mountain Care Board obtaining more authority and power over our healthcare system. That is a major concern. When can they deny a transaction if it's for the good of the hospital? You talk about privatization of healthcare is increasing, and perhaps it is, but also we're seeing more. Not that socialism is a bad thing. I think some socialism is good, but we're seeing increasingly socialism in our healthcare system as well. And the video, although tragic, it's only one part of the story. I'm sure there are others that perhaps would maybe give the equity firm, show it in a different light, maybe in a more favorable. Maybe not with this particular situation, but in other cases where perhaps it's helped our healthcare system. So with that, I'm just going to be quiet. I've said enough already.
Do you have any thoughts, Sam, on?
Yeah, as I said, I appreciate tough questions and criticism like that. I agree with you. Like, this bill is not designed to solve our affordability and access crisis. So I would think of it more as trying to prevent things from getting worse. I think the legislature this year is contemplating a number of bills that would directly impact access and affordability. This is more of and I hear your concern about regulatory structure. Given where we are federally, I'll just speak generally, there is not a lot of federal oversight in this area. And if we accept the premise that we need oversight and we need transparency, there is not really another entity other than the Green Mountain Care Board, the Attorney General. I mean, the AHS does some regulation in the nursing home area, which I didn't really touch on. And I can talk about that another time, perhaps, because it's pretty detailed. And I'm also not an expert in that area. But what I would say about the Steward case is I don't know of anyone that has defended the private equity firm in that. Dr. Kane did lay out yesterday an example of a joint venture with a private equity firm that was beneficial. So this bill does not prohibit those types. Really what it does is provide rules and safeguards. If you want to invest, if you're a private equity firm that wants to invest or do business in Vermont, these are the rules that you have to follow. And really it's a statement of what is most important to the state, which is, maintaining safe staffing ratios, making sure corporations aren't deciding what providers do and how many patients to take, what types of insurance types to take, and preventing firms from extracting wealth privately and using it, quite frankly, to buy jets and things like that. I think that's where I hope that the bill lands, because I think there's a lot of consensus there. And I do think there needs to be clear parameters for what the board can and cannot do. There are in the bill, there are clear criteria for denials. I would say they're relatively narrow. I mean, a firm might say they're burdensome, but I think that there are things that this committee, I mean, they're very aligned with the guiding principles of this committee itself. So those are the criteria that the board would have to follow by law. But I appreciate yeah.
Thank you for your counterpoint.
Hopper?
You may not know the answer to this. The Attorney General's office.
Yep.
Last time I checked, there's a consumer protection division there. Do they have they been involved at all in this?
I would say not formally. I mean, I don't know if you want to.
My next question going to be why?
Yeah.
And I know you put in here, they don't have enough resources,
Yeah.
but they could at least trigger it.
So can you say more what you mean by trigger it? Meaning, yeah.
Start an investigation. Maybe they.
Yeah. Yeah, I mean, I can't speak for them. I think this stuff is really challenging. You need resources to do it well. My understanding, and you could ask them, is that they don't have the authority to do this type of enforcement currently. That's my interpretation of the statute. Like, consumer protection is predicated on, we have a regulatory process that understands what's going on, and the transaction details are public. Really what we have right now is a patchwork of different statutes. We have a hospital conversions statutes that deal with transfer of charitable assets. Like, there's some good pieces in there. This bill builds on that. There's AHS CON review of nursing homes. There's some good pieces there. This builds on that. So this isn't necessarily, this definitely is not like throwing all that stuff away. It's strengthening the things that we already have and unifying it in a more coherent way. So I hope you're not hearing me being critical. I mean, a lot of these, bills and statutes too, like, they were written before this was a big problem. This is still a relatively new area. And I think Vermont rightly prides itself on being forward thinking, but this is also moving really fast in terms of the scope and scale of these transactions. So folks can say, oh, are you being overly alarmist? Like, I would rather be overly sensitive to this possibility and mitigate a Stewart type situation, so long as, the burden is not overly intrusive, and striking that balance is a challenge. And that's the challenge for us in the off season. I don't know why I'm still saying that, but, and that's a needle to be thread, to be sure. But I think the resources piece, I mean, like, we ask a lot of the board. We also ask a lot of our AG, particularly in this time. And that's a healthy conversation to have.
Questions? I have one, but I'll hold. Oh, Mari?
I would just encourage folks to look through the rest of your presentation.
Oh, yeah, sure.
Pretty clear. Maybe I'm at the other end than Woody.
All right.
I look at your presentation and I listen to what we've heard from in the last 2 days. When we talk about the fragility of our healthcare system in Vermont as it currently stands. I worry because it is in such a fragile state that, to paraphrase our healthcare advocate, a payday loan. When you're desperate, you will do desperate things. But I'm also looking at, like, I'm staring right now at the common PE tactics slide. We're relegating this to private equity. Aren't we? If we ask the questions, could we make a case that we're actually already seeing this sort of thing happen in some ways in the state of Vermont?
Yeah.
And we're not regulating that at all.
I wouldn't say at all. That's a really good point. Yes, we are seeing it. And one kind of counter argument I've heard is that, it's not here yet. Maybe we can't do business here. Maybe, private equity firms can't make money here. They are here already. I think the private equity stakeholder project has a map of percent ownership for different areas. The biggest involvement is in nursing homes in Vermont. I think it's around 20% are PE owned. There also are hospitals that are entering into contracts with PE affiliated companies. We have Medicare only ACOs like Rep. Cordes mentioned yesterday that have private equity backing. And there are rumors also of other private equity firms investing in providers as well. And I think the oversight of that is insufficient. I mean, that's something that I focus on a lot. I don't feel like I have good, and I would think that if anyone would, it'd be our office or the board. So it's not a question of if, it's the question of when, to me. And I think this committee rightly prides itself on being forward thinking, and I think we need to be prepared. I know it can feel a little bit awkward in the midst of a crisis to think about the future, but I think some of the best legislating happens when you're doing both at the same time when you can. And we need to protect our healthcare system. It's essential. So yes, to your point, there are some regulations in place, but oftentimes, the PE firms are very savvy, and I'm just going back to Massachusetts, like they have a really robust regulatory structure. They have many more staff than the Green Mountain Care Board does, but they didn't have necessarily the statutory authority, and they didn't have the transparency disclosure pieces that I think this bill makes a really good progress on. Because we need to understand this stuff. And I think we've all gotten really long, heavy legalese documents, like when we sign user agreements for, iTunes or our phones. It's like, does anyone read all of those? Like if a regulator is getting that, like that's going to be really challenging for them. So I hear, Rep. Page, your point about the board. I think we need to make it as easy on providers that are reviewing these contracts so they know what they're getting into, and also for the public. Public needs to know what's going on. We have an obligation to the public to understand what's happening, and the board and the AG needs to know. They're doing an enormous amount of work. We all are. So to me, we need to make this process as streamlined and as transparent and clear as possible.
Madam Chair, I would like to request that as we continue along this, that we have if we have any power to do it, is the private equity firm that's at Springfield Hospital now. I would like to have them come in so that we can talk to them about I'd like to hear the story about what happened in Springfield. Because my understanding is they were there when Springfield first was starting to be in trouble, and now they're bankrupt. So I'd like to hear from them personally.
They went bankrupt, they're out of bankruptcy.
They're out of bankruptcy now? Well, good for them. Then maybe that will give us an idea of what did the private equity firm do when they were in deep trouble? And if they helped them get out of bankruptcy, we'll find that out. But right now, if I'm the Attorney General in the state of Vermont, I'd be all over this thing. And it doesn't appear that that's happening.
So
We
you
should have
indicated we should,
The Attorney General should be there. I'd like to have them in there too.
so and you mentioned this early on in your subsequent slides, is it the intent that there are areas of improvement for H71?
Yes.
And that in the off season, let's see if we can get something before football starts up. That you'll be working with other stakeholders
Yes.
to address this, and then next year if the committee so desires, we will take up sort of a more comprehensive stakeholder engaged compromise, and that is an excellent place to start, I think, with your suggestion. Does that sound good?
Yeah, that sounds good. As long as we do it before we do anything major.
Okay. Yeah, again, I just want to reiterate that I asked people to come in today to introduce the topic. We have several Senate bills coming over, some that are going to take time. We just don't have the capacity this year, frankly, to do this. I think this is something that really needs a lot of work, and if we're to move forward with something like this.
Yeah, and Madam Chair, we also know, I like to look at things as, what do we know? So we know people are being harmed. And I'm thinking, man, you go to a hospital, you expect it to be taken care of. And we hear every day about how long people with mental health issues have to wait around. I'm just, I want to do something about it.
Can I let Leslie go next? Leslie's had her hand up for a while.
Very patient. I'm also a co-sponsor. I also really want to see this bill move. And I'd like to understand, and I understand we have a lot on our plate, we have a lot of work to do between now and the end of the session. But I would like, if we could, to take some time to tee up people now to inform the group that's working on the off session. So I'm not exactly sure who would be the right people necessarily. I'm hearing this, learning. But I would really like to be able to go into that work informed so that when we come back next year, we launch. Because this is big and this is hard, and I'm a copper, scares the daylights out of me that people are dying in the emergency room. And we can't have that happen in Vermont. So, and that's our job that I'm feeling right now. So whatever we can do to tee up what you need for your summer work with testimony, I would like to see if we can do that.
Okay. So let's see if we can fit in some time to do a little bit more. Woody?
Yes, I'd like to know, and you may not, are there any hospitals in Vermont currently that are in jeopardy of being acquired by an equity firm? And if there are there things that we can do now to prevent that from happening until we can actually work on a proper base?
I think that there may be a potential vehicle that is something that we could do. We have I can't get that, 126. And there are many things in there, and perhaps it's something that we can ensure in the near term. We've set up some guardrails before we can get to more comprehensive. So
I'm not saying I'm going to support
yeah,
it.
that's not what I'm saying. That means you're voting yes, right? I gotcha.
This is
Let's have a conversation.
Yeah.
Let's have a good conversation. Yeah, and then Daisy, and then we're gonna.
Woody
finish
asked
on-
my question.
Oh, okay.
Oh, sorry.
Can I just say something that I know it's quite a few times, but I think it bears repeating again? Mike Fisher. Easy answer that legislators in other states have gone to, that I think is a real risk for this effort, is a simplistic private equity equals bad.
Private equity, what?
Equals bad.
Oh,
And I really want to caution us here, that kind of an approach will kill this effort. We're trying to regulate bad behaviors that private equity firms often take. And so there are examples that people bring up, oh my God, private equity is in this hospital or that hospital. That should concern us, and we should look carefully at it, and it should give us motivation for passing a good, strong regulatory bill to make sure that the bad behaviors don't happen. But I just want to caution us that, in my opinion, the right strategy and the right approach is to regulate bad behaviors. So, yeah, I want to say that again. It's been said a few times. I'll say it.
All right.
Just tag on to that, the example I gave yesterday of my healthcare center in Bristol is somewhat of an example of that there's an private equity backed company that provides ACO services, and that seems to be working well for the healthcare center.
Thank you. Thank you so much, Sam. All right, and I think we're not going to take a break since we had a long break for technology break.
Break for tech.
And move to a walkthrough that legislative council is going to walk us through S-28.
Easy has that super cocoa.
So you don't rush through this.
They're pretty good. It's like coconut taffy. Oh, I'm sorry, we're still on live.
Thank you.
Oh. You can say that.
Chest 48.
48 or at 26?
28. I think Jen's coming up there.
Okay.
Good morning, Jen Harvey from the Office of Legislative Counsel. For your patience. Language up on the screen and we will walk through it. Right, so we are looking at S-28, I believe, is that correct? Right, great. S-28, an act relating to access to certain legally protected healthcare services. And this is a Senate bill that has come over to you. So this bill does a number of different things, and the order is really based on, I think, numerical order through the Vermont statutes annotated. So we are starting in Title I and Section 1, although it's not that many sections. So Section 1 is adding a new exemption to the Public Records Act. In the Public Records Act itself, there are a number of listed exemptions where records are exempt from public inspection and copying. There are a number of other exemptions spread throughout the statutes themselves, but this one would go into the list in 1 VSA 317C, and this would add an exemption for records held by the Office of Professional Regulation, Board of Medical Practice, or another public agency that issues one or more licenses, certificates, or registrations to engage in a state-regulated profession or occupation, if the records contain the telephone number, email address, physical address, or mailing address, or a combination of an individual who has applied for or been granted a license, certificate, or registration to practice a profession or occupation in the state, except that the public agency shall disclose any address that the individual has designated as a public address in the record.
May I interrupt you?
Yes.
Could you give us some guidance on how to find what this version, because the version we have posted is the one with the Z's and the red.
It's the unofficial.
Yes, this is the
Unofficial.
So if you go onto the legislative homepage and you type S-28 into the white bar and
Unofficial.
you pick the as passed by Senate unofficial. Unofficial is the version created by my office that I find easier to read than
Well,
the.
this is the unofficial one, the bottom, the Z's. I just scrolled down on the bottom of all the Z's.
The bottom of all the Z's, you get a red italicized version, which is also good. I just find this one easier to read. So this is the
Okay.
unofficial version that Legislative Council creates. And I compare both of them to make sure they look the same. And Yes, so unofficial is, it should still be an accurate representation. It's just not the clerk or secretary's version, so it is not the official.
Thank you.
All right.
For the bill.
So that was section one. So section one, as I said, of just summarize, is creating a new exemption from the Public Records Act for records held by Office of Professional Regulation, Board of Medical Practice, or another professional regulatory body that has contact, home, telephone number, email address, physical address, or mailing address that's not a public address for somebody. So if somebody is looking to contact a practitioner and wants to get their home address, for example, they would no longer, to the extent they can now, be able to reach out to the Office of Professional Regulation or Board of Medical Practice to try to get their application in order to be able to see their email address, their physical home address, telephone numbers, et cetera. Section 2 amends some general OPR statute on unprofessional conduct. So section 2 is in Title 3, and this is professions regulated by the Office of Professional Regulation, and they have an unprofessional conduct statute that goes across all of the professions that they regulate, as well as some individual ones in Title 26. And so this is amending some provisions from the OPR professional regulation statutes. And the lead-in language for this list is that any one of the following items or any combination, whether committed in or outside the state, shall constitute unprofessional conduct. And so this is adding, and by way of a little bit of background, for those of you who were here a few years ago, you may remember, and we'll be looking at this in the next section, section 3, that there was provisions added around specific to advertising by limited services pregnancy centers. And in this bill, it's expanding the scope of that to apply to really all healthcare services in the state, and fraudulent or deceptive information about advertising about healthcare. And so as part of that, we are adding some of these concepts into the OPR and Board of Medical Practice regulatory statutes so that they have the ability to enforce. So some of it will make more sense when we look at section 3. But here, this is expanding what constitutes unprofessional conduct in the area of advertising. Under current law, it prohibits advertising that is intended or has a tendency to deceive. This is specifying that the advertising may include advertising about healthcare services that either has a tendency to deceive or to mislead. It adds to an existing unprofessional conduct statute on delegating professional responsibilities. And under current law, that is delegating professional responsibilities to a person whom the licensed professional knows or has reason to know is not qualified by training, experience, education, or licensing credentials to perform them, et cetera. This is specifying, again, that the professional responsibilities include the delivery of healthcare services, if that's relevant, and that the person is not qualified by any combination of training, experience, education, or licensing credentials. And I think there was some concern in looking at this that about the extent of the burden placed on the person who is delegating professional responsibilities to be personally familiar with the person's education, for example. But if they know that they have competence by a combination of training, experience, education, and licensing credentials, that may be appropriate as far as looking at whether unprofessional conduct has occurred. Under existing law, again, it's unprofessional conduct to permit one's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for the professional services provided. This is adding or actively overseeing. So permitting one's name or license to be used by someone else when not actually in charge of, responsible for, or actively overseeing the professional services provided. And then under healthcare providers, specifically in an existing provision, and you'll see this change pop up in a couple of other places as well. And I think we talked about this the other day in the definition of healthcare services, making sure we're including counseling, which may or may not be separate from procedures, products, devices, and medications, but seems important to include as well. Section 3 is amending that language I mentioned that is in existing law specific to pregnancy services centers to apply more broadly to healthcare services. And this is a subchapter in the Consumer Protection Act. So it would remove a lot of findings that are specific to crisis pregnancy centers or limited services pregnancy centers because of the expanded scope. And so what would remain of the findings is that the General Assembly finds, scroll down to what's getting crossed out, General Assembly finds that telling the truth is how trained healthcare providers demonstrate respect for patients, foster trust, promote self-determination, and cultivate an environment where best practices and shared decision-making can flourish. And without veracity in information and communication, it is difficult for individuals to make informed, voluntary choices that are essential to one's sense of personal agency and autonomy, and also retaining advertising strategies and educational information about healthcare options that lack transparency, use misleading or ambiguous terminology, misrepresent or obfuscate services provided, or provide factually inaccurate information are a form of manipulation that disrespects individuals, undermines trust, broadens health disparity, and can result in patient harm. So again, those are in the existing statute, but they're in with a list of additional findings related specifically to limited services pregnancy centers that would be removed. In addition, it would strike intent language and that is specific to pregnancy and limited services pregnancy centers to have a broader application. Also amend in that same subchapter 2492, which currently has a list of definitions, and because much of the language of this subchapter would be repealed, most of those definitions would no longer be used, so are no longer necessary. But one that would remain and would actually be added here that is consistent with the definition we were just looking at in the OPR statutes, is definition of healthcare services, which are services for the diagnosis, prevention, treatment, cure, or relief of a physical, dental, behavioral, or mental health condition or substance use disorder, including counseling, procedures, products, devices, and medications. Then in the existing section 2493 on the Unfair and Deceptive Act, it would have as an unfair and deceptive act and practice in commerce and a violation of the Consumer Protection Act. And it would expand from a limited services pregnancy center to any person to disseminate or cause to be disseminated to the public any advertising about, and this would be about healthcare services or proposed services performed in this state, as opposed to the services performed at the limited services pregnancy center, that is untrue or clearly designed to mislead the public about the nature of the services provided. It talks about what advertising includes, and the changes to this list. First, just our style has changed as the internet has gotten more common in our daily lives and statutes to not capitalize internet anymore. I expanded web ads to advertisements, and then this would add social media. For purposes of this chapter, advertising, and again, not taking out the reference, and in this case, taking out the provision of services by a limited services pregnancy center. So advertising about healthcare services is an act in commerce. It would also take out language in existing law that requires healthcare providers or makes healthcare providers who are certified, registered, or licensed under Title 26 and employed by, contracted to provide services for, or on behalf of, or volunteer to provide services in a limited services pregnancy center, making them responsible for conducting and providing the services, information and counseling there, and adding some specific kind of oversight responsibilities and connections to the unprofessional conduct statutes, and instead applying these same provisions more broadly through the unprofessional conduct standards to all practitioners practicing in any setting. And then finally, we just have a conforming change to reflect that there is only subsection A left in this section.
Anybody have any questions so far?
I have one,
Okay, let's
if I can find it.
take
Oh, okay.
Copper's question.
Want me to do it right now?
Yeah, I just find
What
that
does-
it's better to ask sort of as we go along.
It's on page 8, line 13.
Okay.
For purpose of this chapter, advertising about healthcare services is an act in commerce. What's that mean?
That means it's subject to the Consumer Protection Act. So advertising about healthcare services, because the Consumer Protection Act and the authority of the Attorney General under the Consumer Protection Act is specific to acts in commerce. This is making this advertising about healthcare services subject to the Consumer Protection Act.
So, if a private equity firm was advertising services, they would come under this, right?
I mean, they would, to the extent that any, so what this says is at the beginning is it's an unfair and deceptive act and practice in commerce to disseminate or cause to be disseminated to the public any advertising about healthcare services or proposed services performed in this state that is untrue or clearly designed to mislead the public about the nature of services provided. So then it's subjecting advertising about healthcare services or saying advertising about healthcare services is an act in commerce. If any person, including a private equity firm or someone affiliated with a private equity firm, is disseminating or caused to be disseminated information about advertising about healthcare services that is untrue or clearly designed to mislead the public about the nature of the services provided, that would be an unfair and deceptive act and practice in commerce and could be pursued by the Attorney General's office under the Consumer Protection Act. It's not any act by a private equity firm. It's treating them the same as anybody else under this statute.
Thank you.
Ready to move on?
Yes. I'm I'm just going through this and I'm having flashbacks. Are we essentially repealing and striking out? And I realize we're replacing it with other language in a more broad fashion. But are we striking out what we did, was it 2 years ago, around limited services pregnancy? I mean, that's all gone.
Right, it would be expanding the scope from focusing on limited services pregnancy centers to apply more broadly.
Okay.
But they will be subsumed in that, so we're not losing it.
Right, I mean, all actors would be subject.
Gonna say something flippant, but I'm just remembering all the conversations. And I'm like, well, that was a waste of time coming up with that language. Anyways.
No, it led to this.
Keep going.
It led to this. Gave birth.
Sections 4, 5, and 6. Section 6 is the substantive piece. Sections 4 and 5 are sort of cleanup language getting us to section 6. So as I looked at, as I looked at the language that we were going to amend in section 6, it uses the term physician, and it made sense. As you'll see in a moment, it has to do with reports of fetal deaths and who might be making reports. It made sense to broaden the reference from specifically physician, which it is under the current statute, to healthcare professionals more broadly. As I looked at the definitions in this part, and you'll see on line 10 on page 9 here, it says, as used in this part. We don't usually talk about parts of the statute, but if you were to open up the green books and look at the very beginning, you would see they are all, before you get to the chapter level, arranged into parts. And parts generally deal with a very broad topic. I believe this one is birth, either vital records or birth, death, and marriage records or something like that. It's very broad. And then there are a number of chapters within a part. And so in this case, in existing law in section 4, there are definitions defined for the entire part, the entire group of chapters dealing with vital records, birth records, death records, marriage records in Title 18. And the way this was amended last year, I believe, for a different purpose having to do with allowing naturopathic physicians to sign birth and death records in the government operations that went through the Government Operations Committee. They added a definition for the whole part that says licensed healthcare professional as used in one chapter of the part means a physician, physician assistant, naturopathic physician, or advanced practice registered nurse. That didn't, and then in the actual section where it gets used, or I guess where we're using it here, there is no definition. So in chapter 107, there is no definition. It's just at the beginning defining a term for use in one chapter. That didn't work for me as a drafting purist. So while I was in here, I cleaned it up. So now it would say licensed healthcare professional means a physician, physician assistant, or advanced practice registered nurse. And then as used in chapter 107 only, which is really what this was doing, the term also includes a naturopathic physician. And then we get to that chapter 107, and we add a definition here as well of licensed healthcare professional means a physician, physician assistant, naturopathic physician, or advanced practice registered nurse. Which gets us to section 6, which is the whole point of having this definition of licensed healthcare professional. This is a statute on fetal death reports and requirements for fetal death reports. It's an existing section of statute, but as I said, in existing law, it requires certain fetal deaths to be reported by the hospital physician or funeral director. And as this committee knows, there are a lot of other types of healthcare professionals other than physicians who may be involved in providing patient care in these circumstances. So this would say following fetal death shall be reported by the hospital, licensed healthcare professional, or funeral director directly to the commissioner within 7 days after delivery on forms prescribed by the department. And there are certain requirements, and again, now I'm just making the list make more sense. So they have to report all fetal deaths of 20 or more weeks of gestation, or if gestational age is unknown, of 400 or more grams, 15 or more ounces. And in those cases, fetal weight shall be reported. All therapeutic or induced abortions as legally authorized to be performed of any length, gestation, or weight. And then it specifies, and this is why it's pulled back out, so it doesn't fall under number 1 here. Spontaneous abortions, miscarriages, and ectopic pregnancies of less than 20 weeks gestation are not required to be reported. Then we have, again, existing language, just changing physician to licensed healthcare professional, using non-gendered language to refer to the medical examiner, and changing a couple more instances of physician. And then what we're really going into this section to do is to say that reports made pursuant to this section are for, which it already says fetal death reports, but there are some other types. So reports made pursuant to this section are for statistical purposes only and are not public records. That's existing law. And under existing law, the records shall be destroyed after 2 years. This after 5 years. This would increase that to after 2 years, but would also add that these records shall be kept confidential and shall not be disclosed or discoverable in any civil, criminal, administrative, or other proceeding, and then shall be destroyed after 2 years instead of 5. All right, section 7 is unprofessional conduct under the Board of Medical Practice statutes. I started out just by putting in some subsection headings because there was one later in this section. So just kind of naming this subsection A as prohibited conduct. And it's similar language to what was used at the beginning of the OPR statute, that the board shall find that any one of the following or combination, whether committed within or outside the state, constitutes unprofessional conduct. And a lot of these, again, will look similar to what you saw in the OPR statutes. Although here we are talking specifically about healthcare providers. So Bessie, all advertising, and under existing law, it's all advertising of medical business. This would modify that to say all advertising about healthcare services or a medical business. And under existing law, that is intended or has a tendency to deceive the public. This would add mislead or deceive the public. And then under existing law, we keep or impose upon credulous or ignorant persons and so be harmful or injurious to public morals or safety. There is existing language about permitting one's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for the treatment given. This would modify that to say when not actually in charge of, responsible for, and then add or actively overseeing the treatment and adding or other healthcare services provided.
What does actively overseeing actually mean?
That would, I mean, that would be up to the board to determine what active oversight looks like. So you may want to ask the board.
Okay.
This was language worked out with the Board of Medical Practice, Office of Professional Regulation, Medical Society, and BOS. Delegation of professional responsibilities, and this would add including delivery of any healthcare services to a person whom the licensed professional knows or has reason to know is not qualified, and this adds that same by any combination of language from the OPR statute, training, experience, education, or licensing credentials to perform them. Then this is a new provision we haven't seen yet, but you will see coming up in a later section as well. This is an existing provision of law that deems as unprofessional conduct providing, prescribing, dispensing, or furnishing medical services or prescription medication or prescription-only devices to a person in response to any communication transmitted or received by computer or other electronic means when the licensee fails to take the following actions to establish and maintain a proper physician-patient relationship. Again, this is existing law. A reasonable effort to verify that the person requesting medication is in fact the patient and is in fact who the person claims to be. Establishment of documented diagnosis through the use of accepted medical practices and maintenance of a current medical record. Then under existing law, for purposes of this subdivision 33, an electronic, again, just updating some language here, online or telephonic evaluation by questionnaire is inadequate for the initial evaluation of the patient. Now here's where we get to new language, except as otherwise provided in subdivision C4 of this subdivision 33.
Mari, did you have a question?
Yeah, I know we're not doing markup now, but on page 12, line physician relationship, I just lost it. Where is that?
Oh, on set line 17.
Yeah, should we change that too?
Perhaps this is, I mean, this is the Board of Medical Practice statute, so it is.
I see like physician assistants.
It is right. It is overseeing physicians, physician assistants, podiatrists, radiologist assistants, anesthesiologists, I believe. But I don't know the extent to which, certainly for physician assistants, it would be broader. We can talk to the Board of Medical Practice, see if they would have any concerns.
Okay.
So this is, we're getting into the important part of this change. So for purposes of this subdivision 33, an electronic, online, or telephonic evaluation by questionnaire is inadequate for the initial evaluation of the patient, except as otherwise provided in subdivision C4. The following is not a violation. So these are some other existing provisions. And then what would be added here is in furtherance of 18 VSA chapter 223, which is the chapter on reproductive health autonomy, prescribing medication for an individual to terminate the individual's pregnancy based on an adaptive questionnaire that allows the licensee to obtain additional medical history and ask follow-up questions as needed. So this creates a new exception to the general prohibition on providing medical services based on a questionnaire if it is medication for an individual to terminate pregnancy, and it is an adaptive questionnaire that allows the licensee to obtain additional medical history and ask follow-up questions as needed. And then it renumbers the remaining subdivisions. That was all in the in subsection A. Subsection B, we have just given subsection headings, so failure to practice competently and burden of proof, but the content has not changed. Existing Subsection D, actually D1 is labeled healthcare provider, so we would leave that as D. And then E, subdivision 2 becomes subsection E, and the definitions would apply to the whole section. We have definitions of healthcare provider, healthcare services, and legally protected healthcare activity. And for our purposes here, this is adding on line 7 of page 15, counseling under healthcare services. Section 8 is in the provision in, or one of the sections in Title 26 on advanced practice registered nurses. And this is putting in that same carve out for advanced practice registered nurses to the existing prohibition on evaluation by questionnaire to allow, again, in furtherance of that chapter on reproductive health autonomy, prescribing medication for an individual to terminate pregnancy based on an adaptive questionnaire that allows the licensee to obtain additional medical history and ask follow-up questions as needed. Next two sections are just some conforming changes to align other Board of Medical Practice statutes with the unprofessional conduct provisions that were amended in section 7. So for certified anesthesiologist assistants, this is adding that any combination of language around the delegation of professional responsibilities. And the same in section 10, which is the statute on physician assistants. Oh, there's a couple of changes here to be consistent with that Board of Medical Practice statute. So occupational advertising, and then adding or advertising about healthcare services that is intended or has a tendency to mislead or deceive the public. And adding a definition of healthcare services that it matches the other definitions added in the other sections or existing in the other sections. Finally, section 11 is in the pharmacy statutes, and this relates to confidentiality of prescriber information on medications for legally protected healthcare activity. So this uses the same definitions of gender affirming healthcare services and reproductive healthcare services that exist in Title I as added by a bill worked on in this committee and others a couple of years ago. This allows, upon request of a prescribing practitioner, and to the extent not expressly prohibited under federal law, this directs a pharmacist not to list the practitioner's name on a fulfilled prescription for medication for gender-affirming healthcare services or reproductive healthcare services, which shall instead list the name of the facility at which the practitioner is employed or as a contract employee. And then some kind of additional related language saying that nothing in this chapter or the rules governing the pharmacy profession shall be construed to require a pharmacist to list the prescribing practitioner's name on a fulfilled prescription for medication for gender-affirming healthcare services or reproductive healthcare services. So C just gives reassurance to the pharmacy profession that nothing that they are doing, that they are not being required by their regulators to list that information.
Oh, go ahead, Woody.
Does healthcare services, reproductive healthcare services, does that also include individuals that give abortions?
I mean, I believe reproductive healthcare services includes that, yes, includes the whole gamut of reproductive healthcare services, including abortion services.
But just medication, just medication.
This is just medication, right? This is, right, if the prescriber requests and it is not expressly prohibited under federal law, the name of the facility where they work, not the individual practitioner's name, would be listed on the dispensed prescription.
So this is new.
This is new.
What if you are a prescribing practitioner and you do not wish to disclose your name, and yet you're not either employed or a contract employee or work? What if you're just in private practice?
And I believe your name would have to be on there so that there could be follow-up if something, if there was a problem with the medication.
So the only way we're actually able to protect somebody is if they're working for somebody.
that's what this language says. There may be other ways to go about it. You would want to, I think, hear from the Board of Pharmacy and perhaps providers.
I was in my old practice days, we were an independent practice, but we were Rockingham Medical Center. So we couldn't just say that,
Right.
not have a name. So it's just a facility, not necessarily an employer.
Yes, but if your facility name is the same as your name,
Right, then you would have trouble. Well, then.
Right, and I need to look into what is required to be provided under federal law, because I do think some information about the source of the prescription, and the prescribing authority is required.
thank you, sorry.
All right, oh, I said we were done. We weren't quite done. 12 is that same, just because of the numerical order of the sections in title and the chapters in Title 26. So we have, again, another conforming change for the certified radiologist assistants to the Board of Medical Practice on professional conduct statute language about any combination of training, experience, education, or licensing credentials. Finally, Section 13 is the effective date, and it would take effect on passage.
Thank you. Leslie?
I'm still musing on this question we just had. What's a facility? You could name a facility.
Well, like Rockingham Medical Group, but medical
But
group.
the name of a person is not necessarily a facility. I'm just trying to get.
And I think that's the difference, is that it could list the name of the facility at which the practitioner is employed.
So it wouldn't be the name of the practice. I mean, that's what I'm a little stuck on.
Let's say you're in private practice, Dr. John Smith.
Yeah.
Your facility would be the office of Dr. John Smith.
Where you get your mail. Okay.
Post office box.
And it would be the address where you're practicing.
Would be identified. I'm just wondering about a different word, but
Yeah.
Using.
How to protect that. Any other questions for Jen? Anything not understood or clarification on any of the language? Okay, great. So first, we're going to hear from Oz.
There's one time where I stumbled in Senate Finance, and the only thing that stopped me from falling was grabbing onto Kevin Mullins' lapel. You look pretty surprised, yeah. Good morning, my name is Devin Green. I'm with the Vermont Association of Hospitals and Health Systems. Thank you for having me in today. We do support this bill broadly, so I'll just go through a couple things and keep it brief. So sections 1 and 11 that support provider privacy, we wholeheartedly support these sections. I'd like to point out that the section 1, which protects healthcare providers from public records requests, is tied in with workplace violence prevention and helping in that area. So we wholeheartedly endorse those pieces. And then for the unprofessional conduct sections, in the original version of the bill as introduced, we had some concerns around some words being a little too vague. There was a prohibition around providing confusing information, which seemed a little vague and overly broad to us because facts can be confusing to people. And so we worked with the Office of Professional Regulation and Board of Medical Practice, and we appreciate the work that's been done there and how these sections have turned out. We think they address the issue without, being overly broad. And then we also support section 3, and we appreciate the work with the Attorney General's office on this for prohibiting untrue and misleading statements. And in general, we support the bill as a whole.
Okay. Any concerns around any language that still might need, or you're good as passed by the Senate?
We're good as passed by the Senate. If you all want to, I understand Representative Goldman's and your concerns about individual providers and protecting them. And happy to support that as well, but otherwise, no.
Any questions for Doug?
In your work with the Attorney General, were you assured that they had the resources to perform the job that they're supposed to do?
We did not get into their resources. We more talked about the language as opposed to the enforcement, but there was nothing that led me to believe that they did not have the resources for this.
Great.
Thank you.
And Jessa, I'm trying to be more Ms. Barnard. I'm trying to be more formal.
Fancy.
But then I see that and I'm just like, that sounds ridiculous. Come on up, Jessa.
You're welcome to call me Jessa. Thank you.
Ms. Barnard.
Ms. Barnard, who's that? My mother-in-law. Good morning. Thank you very much. Jessa Barnard, the Executive Director of the Vermont Medical Society. We are also very much in support of S28 as passed the Senate. And just to step back for 1 minute about where it came from, since some folks are newer to these issues, this bill really grew out of Acts 14 and 15 of 2023, which we refer to as the SHIELD laws, to protect both providers, but also patients and people assisting patients who are seeking reproductive or gender affirming care services. And we are seeing, since the passage of those laws, more actions from other states that are showing why we need them and how they are already being called on in other states to protect patients and providers. So we really went through over the summer and fall with some other partners, what might the gaps be that those laws left, or what are we seeing coming out of either other states or federal actions that might leave some areas to strengthen. So that's really where the bill came from, and we think it does a great job to close some of the gaps that we've seen since the passage of those laws. So again, we support all sections of the bill as written. I won't repeat some of the pieces Foz just testified to, but again, we strongly support the contact information of licensees not being subject to public disclosure. I know you'll be hearing from the board and maybe you'll be hearing from OPR, but I would encourage you to, they gave us some examples of the types of this is actually, it is a workplace safety issue. They also gave some examples of of using this for advertising purposes, CME, continuing education companies just doing a blanket Public Records Act request for all licensees, and then they're marketing educational things or products or services. So it's being used in all sorts of ways. It can be used for harassing and also threats of violence. I believe both the board and OPR try to advise licensees, that this is public, don't list home contact information, but sometimes that gets missed and the board and OPR wouldn't know which type of address is listed. So we see this as very important for all licensees across the state. We support, I can kind of, in my testimony, combine sections by topic. So sections 2, 3, 7, 9, and 10, I'll talk about truthful advertising. Again, you already heard some of this, but we worked with OPR, VAWS, the Board of Medical Practice, when the bill was in the Senate, and we support where these sections ended up. We think they strike a good balance between prohibiting misleading advertising and requiring oversight when delegating services without being overly broad to restrict necessary coordination in healthcare. And we are also comfortable with the language in Section 3 around the consumer protection laws, stating that healthcare services cannot be, or advertising for healthcare services cannot be untrue or designed to mislead the public. Sections 5 and 6 that dealt with the confidentiality of fetal death reporting. We support the clarification that those reports are confidential. We are also fine with the clarification, or comfortable with clarification that other healthcare professionals can submit such reports. That is current. Our understanding is that was current practice anyway. It was more aligning statute with current practice. I will go into a little bit more detail. Sections 7 and 8 have those sections about allowing an adaptive questionnaire to prescribe abortion medication. So I want to give you a little more detail on what that means, what that is. We support amending Vermont statute to allow establishing a clinician-patient relationship and prescribing via adaptive questionnaire solely for the provision of medication abortion services, not in general. And I will tell you why. There are other companies out there seeking to use, this is sort of you can go to an online company, answer questions, get a prescription mailed to you. Some of them we believe are not necessarily following appropriate evidence, or they're making it very easy for things like hair loss medication, something like that. Just answer some questions, get this sent. However, in the case of abortion medication, there is a lot of evidence that backs up safely and effectively using remote asynchronous care via a published protocol. So what I want to make sure that is clear is, so this would be first the patient goes through and answers a lot of questions that cover all points that would be covered in a live practice setting. But the date of last menstrual period, medications, allergies, medical history, obstetric history, any history of cesareans or ectopic pregnancy. And there was, any other, medications being taken. The physician reviews the form, or the practitioner reviews the form. And the key here is they can ask for follow-up information. So there has to be an opportunity. We agree with and believe, if those raise any kinds of red flags, they can schedule a telehealth visit or exchange asynchronous communications to clarify any question. I've linked to a full description of the protocol used and the screening questions used. I've also included links to a lot of the data that's been gathered, especially since COVID, using these types of protocols to show that the safety and efficacy and outcomes is the same as in-person or other telehealth modalities. And reasons patients may choose that approach are things like cost, privacy, stigma, convenience. And we heard from a family physician, Dr. Clara Keegan, in the Senate Health and Welfare Committee regarding how in-person visits are not necessary to gather necessary clinical information to safely prescribe abortion medications. Currently, Board of Medical Practice statute and policy and OPR statute for APRNs doesn't allow any asynchronous prescribing. And so again, that's why this change is necessary to allow it in this instance. In comparison, guidance from the Federation of State Medical Boards, which suggests policy, does not require it for state medical boards, does allow or make a provision for asynchronous prescribing. And in our view, we think this current prohibition also arguably conflicts with Vermont's SHIELD laws, which prohibits a board from subjecting a healthcare provider for discipline based on providing or assisting in the provision of reproductive healthcare services, as well as statute that says a public entity can't prohibit a healthcare provider acting within their scope from assisting in the termination of a pregnancy. I do want to really note that I think this is really important, that existing statute, which would stay in place and we support, holds a prescriber responsible for meeting the same standard of care when using telehealth versus any other modality of care, in-person care, and requires patient consent. So this would always be the patient has chosen this modality and you don't have to be able to meet the same standard of care. Again, if you had any questions about whether this was appropriate or the safe for this patient's situation, you would have to either have a phone call, in-person visit, refer them to an in-person provider.
Can I interrupt?
Yeah.
You said a few minutes ago, and I understand the reason we're doing this in this particular instance, but you said that providers cannot prescribe using asynchronous
questionnaires.
Correct.
In unprofessional, so state law, so it is that prohibition is contained in unprofessional conduct language for MDs and APRNs. It says you can't establish a physician-patient relationship via a questionnaire.
Okay, so this is establishing the relationship.
It's not in telehealth statute. It's right, because your committee has looked at a lot of telehealth statutes. That's not it's really addressed one way or another in the telehealth statutes. It's in unprofessional conduct statute saying you can't use a questionnaire to establish a physician-patient relationship or physician-patient.
I was just thinking about like portal communications that go
Right,
back and
exactly.
forth and there
Right.
be sort of a, I'm like, wait, I think
Right.
that happens a lot.
Yeah, exactly. And I think there is, yeah, exactly.
Okay.
Yeah.
Thank you. Sorry.
Yeah.
Keep going.
That's a good question. Section 11 is the piece about removing contact information from prescriptions. We have seen cases arising. There's one instance pretty covered in the media recently about a New York physician who's has cases being brought against her both by Texas and Louisiana after prescribing abortion medications to patients located in those states. So we know telehealth prescribing is becoming more and more risky and politicized, and removing prescriber identifying information is one step Vermont can take to try to protect access to evidence-based medications. New York recently passed very similar legislation. I believe it was signed by New York's governor in March. And Washington has a somewhat similar, Washington's a little bit different, but similarly, it's for when it's dispensed from a facility itself, but also makes a provision for removing contact information. I think you raised a great question about that language at the end of the paragraph about being employed. We would support, that didn't really occur to us when we were looking at this in the Senate. VMS would be supportive of broadening that language to, if possible, to apply more to a facility where the practitioner is practicing as opposed to where they are employed, if that could be accomplished in language. And one additional recommendation that we raised in the Senate and then honestly kind of lost track of in all these other amendments we were working on the bill, we would recommend further prohibitions on data sharing regarding legally protected healthcare activity. Right now, the SHIELD laws contain quite good language around sharing information with for the purposes of interstate investigations or proceedings seeking to impose civil or criminal liability for providing legally protected healthcare activity. We would suggest adding the word or federal investigations or proceedings. So where possible, if the state would not have to release information if it was just based on the provision of or seeking legally protected healthcare activity in the state with federal investigations. So thank you. Appreciate your time.
Robert, did you have a question? I thought I saw it.
No, I'm just trying to understand it, that's all.
Yes, well, it's on the subject, but it isn't. On section 11, we're talking about, and I understand why you don't want the prescribers' names on the bottles, but when we start prescribing abortion medications and gender affirming care to other staters, do they come here to get services first, or can doctors prescribe this?
It could be either. So it could be the person is coming to Vermont for an in-person appointment. We know we have lots of cross-state in-person care in Vermont. It could be via telehealth.
And who pays for this?
It would depend on that person's insurance. That's up to their insurance company.
Does
And where
Vermont
they're coming
pay
from.
anyway if they don't have any insurance?
Typically, no, not state. No, I mean, unless they had qualified for Vermont Medicaid, but
Okay.
typically, no, Vermont's not paying for out-of-state care unless they, for some reason, already had Vermont insurance because of where they worked or something like that. I think it doesn't matter what sort of service they are getting, right? I mean, if, say somebody came to an FQHC and qualified for their sliding scale fee, that it would be as if they were getting any other care like any other patient, whether they do or do not qualify
But I
for.
was thinking in these other states that it's not legal, they're going to states where it is legal, right? Especially abortions.
Correct. And some states have actually set up funds to help with things like travel cost and cost of obtaining care, if you have to travel for that care. And some nonprofits have done that, but it's not something currently, I believe, that Vermont is funding currently.
I have two questions, one on section 11. So all we're really doing here is we're not putting a name on a pill bottle. That's it.
Correct. So it would still be in your medical record.
Doesn't protect Margaret Carpenter from Texas or Louisiana.
Unless that is the way they connected her to that patient taking that medication, say the pill, if there was an investigation in that patient's house and they found the pill bottle and that name was on the bottle. But if if otherwise in discovery or they knew through other patient records that was the provider, that's correct. It is not a full protection. It is just one, if the bottle was literally the piece of evidence that could provide some amount of protection.
Vermont has prescription drug monitoring.
Yes, and we looked into whether there needed to
Other
be.
state agencies do other state agencies have access to our own? And do other states also have the same?
So there are very few instances in which entities can get access to the prescription monitoring system. And we also talked with VDH a little bit about that when the bill was going through. And no abortion medications and for gender affirming care, only testosterone would actually be reported in there because it's only schedule, looking at Jen to certainly schedules. I don't want to get my numbers wrong, that are reported.
Yeah.
And those are not scheduled, so they are not in there.
Okay. And then I have a question on section 1, all the way back up to the top. I think I'm a little confused, and I'm asking you because you had the most comments on it. I think I'm frankly a little confused as to what exactly we're doing. I mean, we're removing names and addresses from license, or not names, addresses from licenses.
It's from, go ahead.
No.
That's your question. So it's actually from the full information submitted when you were applying for a license. So that's the distinction. Like all boards also make a publicly searchable database. So you could go in and search up Jessa Barnard I am not, just to be very clear, I'm not a physician. If I were, you could search me, or you could on for the attorney licensing, you can search by my name and find me and where I work. Mm-hmm. The issue is you actually submit a much lengthier application to be licensed or renew your license with all sorts of, have you had any malpractice actions? Have you had a DUI? All these things that you're required, and multiple addresses, multiple points of contact. If there is a Public Records Act request, they have to provide and they could give you more detail which of those pieces they do or do not currently have to turn over. But my understanding is much of it, or they can redact some things that are considered, under existing exceptions to Public Records Act requests. But this would be adding additional protection to say, on that application, they will say, this is your public address. List here your public address. That would still be applicable when a patient wants to go in and search, or your employer, or see, make sure you're licensed. But all the rest, the other addresses you list, or your email address or phone number on your application, if somebody is doing a Public Records Act request directly to the board, that would be redacted and not disclosed.
I'm just thinking of situations where, oftentimes when somebody first gets their license, you get a license before you're actually actively practicing anywhere, and you don't have an alternative address. And most often I've seen them come through with home addresses on them. And once that's in the record, even if years later, you renew your license or anything like that, your old license still stays and you can track back addresses on things. And I'm wondering, is this going far enough?
I think that's a great question for OPR and the Board of Medical Practice to clarify how they would handle that situation.
This makes the assumption that you always have an alternative address.
Right. And I know OPR and the board have addressed that. They try to catch things like that when somebody applies and say, this looks like it might be a home address. Are you sure you want to list it? I don't know, for example, I'm not sure if they allow PO boxes or other addresses. There's also if you recall, in the Shield laws, we expanded OPR's address protection program. I'm going to get the name a little wrong, but you can actually list an OPR address or like a sort of standard shared address rather than a personal address for certain purposes, I think including license applications. But again, they are the ones who really deal with the ins and outs of what they put where on and disclose. So if you have further questions, I'm sure they would be happy to.
Is there anything in here that addresses historical documents? Because as we know, once something's online, it's there forever.
Don't think I think the board OPR again would
Okay.
know if you put something on a past app, I understand what you're saying. You listed it at one point publicly. Now you haven't listed it that way. Would it apply to that? I don't know exactly how they would operationalize that.
Thank you.
I think yes, some of the language, I think itself addresses that. It doesn't require there to be a public address. It just says they shall disclose any address the individual has designated as a public address. And this is all about records held by the office, by the regulatory board. So if they're holding historical records, they would not turn them over in a public records request. Whether they would pull them down from online, I think is a question you'd have to ask them. If they're, if they're already available in other formats, then there shouldn't be a need to make a public records request for them anyway. But they may be looking at taking things off the internet that are currently on it.
Okay, thank you. Sorry.
Thank you.
What do you?
Section 6 talks about privacy. Does an applicant or somebody that's getting healthcare, do they have to provide their name?
Looking at section 6 on the death reports.
Yes. The records are kept for 2 years. And I was just curious whether a patient would have to provide their name.
These are reports being filed by providers, So is your question whether the patient's name would be on these records that the
Yeah.
providers are,
Yeah,
I don't know.
because you're only providing the record of the death of the fetal.
I don't believe that includes patient name on those reports. It's more used for.
They can opt out, I
statistical.
guess.
I don't think it's listed at all. I don't think it's ever included. I believe it's more just for statistical purposes. There is information, I think, about like the type of setting and some other kind of clinical questions, but not the name of the patient, I believe.
Actually, can I ask legislative counsel a question about that? Because I was thinking about this as you were going through it. Is there protection for someone who doesn't report a fetal death? I mean, I'm thinking of 20 weeks gestation. Is there a requirement that you have to report a miscarriage or I'm sorry, spontaneous abortion?
Well, that one for less than 20 weeks, no, but this is all about reports by the hospital healthcare provider or funeral director to the extent, I think it would only be to the extent they have that information.
Okay.
So if something.
So there's nothing that we have that requires somebody who was 21 weeks if they do not report.
If they don't seek
that
medical
there's some-
attention,
If they don't seek.
I would have to look to others. I don't know the answer to
No,
that.
I don't think there's any requirement on the patient. This is all the
Yeah.
facility and provider requirement.
I'm just-
Yeah.
Penalize anyone. Okay, any other questions for Jessa?
Thank you very much. Thank you for taking up the bill.
Jessica? I'm sorry, Ms. Barclay. See, it sounds so silly, actually, doesn't it?
Yeah, that's just fine. Thank you. Hello, everyone. Jessica Barquist, VP of Public Affairs for Planned Parenthood of Northern New England and the Planned Parenthood Vermont Action Fund. It's one of those nice times where I'm going to echo a lot of what my colleagues already said. So we fully support S28 as passed by the Senate, as well as the additional language that VMS just shared regarding limiting that federal data sharing. So this bill is a crucial next step in ensuring that providers can continue delivering essential care without fear of legal threats or political interference. By strengthening these protections, Vermont reaffirms its commitment to healthcare access, bodily autonomy, and the fundamental right of all people to make their own medical decisions. That first section, address protection, in 2023, this body passed a shield law that allowed healthcare providers of legally protected healthcare to participate in the state's Safe at Home address confidentiality program. It's run by the Secretary of State. And so this, that provision that is already law allowed legally protected healthcare providers to keep their private home address confidential. And so this section just extends that protection again to our OPR records. The next few sections, sections 2 through 12 roughly, on updating professional regulation standards. This is a really great next step from the work that was done on the Shield bills to encompass all of our healthcare professionals. And we fundamentally believe that truth in medical advertisement and counseling is foundational to that trust and well-being of our entire medical system. So we as patients often trust our medical professionals to provide us with scientifically accurate information so that we can make the most informed healthcare decisions. And we're really pleased to see that these standards are going to be elevated for all medical professionals. Sections 5 and 6, the fetal death reporting just for providers. We definitely support this clarification of the confidentiality regarding fetal death reporting. And this is a little bit of an aside, but I will just lift up for this committee that the guidelines on best practice regarding fetal death reporting are a topic of much discussion right now under this national landscape. And there is some growing evidence that any fetal death reporting required by a state is harmful. And national experts like the COMS Project are now recommending repealing all fetal death reporting requirements. So I say this as an aside. I think we support this language as is, but this is definitely something that we look forward to having further conversations with the Department of Health about as the research continues to evolve and best practices evolve. Section 7 and 8 around the adaptive questionnaire. This provision is really critical for expanding abortion access in the state, and we fully support it as passed by the Senate. Medication abortion is highly safe, and the questionnaire uses best medical practice to effectively screen out individuals who may not be suitable candidates. And then finally, section 11 regarding the confidentiality of prescriber information. This is really important, and this is one that our providers at PPN&E are reaching out to me all the time about and saying, has that bill passed yet? Is this passed yet? They're really anxious about this. And I want to share a quote from one of our Vermont providers. They say, I am an abortion provider and a clinician who prescribes gender-affirming medications daily. Abortion and gender-affirming care are life-saving health care for many of our community members. I do this work because I am called to do so. However, I practice knowing this makes me a target. The reality is we live in a world where abortion providers have been murdered, their partners and children are threatened, and the risk of violence entering and exiting the health center is something we weigh each and every time we step through the doors. We are seeing increasing legal challenges to this care that is ratified and protected in the Vermont Constitution. We have decided as a state that access to this care is a right, and we are seeing states where abortion or gender-affirming care is illegal, reaching across their borders to prosecute providers. As a clinician who wants to continue to provide abortion and gender-affirming healthcare for our community, I implore the Vermont legislature to remove our personal identity from these life-saving medications, including abortion prescriptions and gender-affirming prescriptions. This will help the providers from becoming targets of personal violence and also help prevent the attempted criminalization from other states. This body has a responsibility to shield the healthcare providers in Vermont from increasing attacks on this safe, legal, and vital healthcare. Thank you. So we really applaud this provision and the inclusion of gender-affirming care in this provision. This protection is just so critical in today's climates where trans rights and trans healthcare is under intense scrutiny and attack. So overall, this bill is basically just providing additional safeguards for our practitioners of safe and legal reproductive health care and reaffirms our commitment to defending our clinicians and our commitment to ensuring that all Vermonters can access the healthcare that they need. So we thank you for taking this bill up and for your continued efforts to protect Vermont's access to legally protected healthcare.
Thank you. Any questions for Jessica?
I got a question for somebody.
Okay.
Why wouldn't we report all fetal deaths instead of under 20 weeks and over? Why wouldn't we report them all? I don't know who would answer that. I think,
Well, let's let our, anyone around the room.
I think it's important data for down the road or, but anyway, that's it. I didn't know who to ask that to.
Miscarriages are a common occurrence among women. They often happen without medical intervention. And so most of the fetal deaths, there is no medical need to report.
Other than data.
What do you have to do with it? What do you do with it?
Yeah, what's the data for?
Yeah.
Down the road, I guess, we keep data for everything else.
I mean, I was gonna ask the question when Jen was talking through it. I didn't know we even did that, and what are we doing with the information?
What do we do
Taking it
with
from
information
storing
on
it.
anything we keep?
Well, we're taking it from storing it from 5 years to 2 years
Just a question.
and reporting on it.
I think it does raise a really good question, though, of why are we tracking that data? What is it used for? And is it really needed? Which is, as I mentioned, part of a more larger conversation that is happening nationally. And other states are moving away from those reports.
Daisy?
I would just say, because I very much care about using data to improve health outcomes. If we're going to collect data, it must only be because we have a reason to collect it and to apply it to improve health outcomes. I can tell you for sure, if I come in here and I see my miscarriages represented by a number on someone's spreadsheet, is going to screw up my mental health more than anything you could do with that number, that figure up there. What's it going to represent? Environmental health of miscarriages increasing? It's nobody's business. I mean, how uncomfortable would you be if I walked in here and said, well, I'm going through a miscarriage right now, so I'm going to be grumpy this week. Sorry, I just had to
I'm
say
not saying you
something.
should be telling me.
Well, I should be telling the
Okay.
world by being a bullet point.
Don't know
I
if-
mean, it's just,
Okay.
I'm sorry, I just have
No,
to
it's okay.
illustrate that. It's very.
No, that's
personal.
fine. That's
And if
fine.
you want to talk very personal, this is what it feels like.
Yep.
Murray.
Just to add to that, it's being, in other states, it's being used to harm people who have had miscarriages and accuse them in states where abortion is illegal. It's been used to harm people who have had miscarriages and have had legal implications foisted on them because they had a miscarriage, but it was called an abortion. And there are even movements to, there are online cycle trackers that people who menstruate can use to determine when they're ovulating, when their next menstruation might be, and for people who want to know what
Okay, but why do we keep the data after 20 weeks
It's-
then?
using it against people. So this is a protection against that from happening.
Leslie?
I'm good, thank you.
Yeah.
Any other questions for Jessica? All right. Well, thank you.
Thank you so much.
I think we're done well, frankly, the committee's done for the day. Oh, wait, can we have a walkthrough? We do. No.
Yes.
Take a vote.
Katie.
Oh, yes, I'm sorry, it's not on the schedule I was looking at. Yeah, we have to take a vote on an amendment. I just thought Katie was coming in because she missed us so much.
Oh, that's for sure.
Katie's gonna walk us through an amendment on 237.
Eight.
H 237.
It's one word, I think, Kate.
37. Still. Let's see if she's up. Let's go. Turn it back.
I realize I am between you and lunch. I apologize. Katie McLean, Office of Legislative Counsel. I don't have a link yet.
Oh, yeah.
You sent it to me. Thank you.
Yeah.
That's a very tiny amendment, so I'll refresh your memory. The bill we're looking at is 237. This was prescribing psychologists. And it went next door and spent a short amount of time with Ways and Means. And they were considering fees in the context of another bill that is kind of creating a catch-all for all specialty fees. So there would be this same fee for all professions that have a specialty, if that makes sense. And that's why your bill doesn't have a fee spelled out, because it would be spelled out in language being created in another bill. So in order to sort of make the pieces fit together, we wanted to make sure, and recognizing that the bill that we're referring to might not pass, we don't want to refer to the fee, because what if there isn't a fee? So instead, in one place it referred to the fee as any fee, and so the other place it referred to it as the fee, we've changed it to any, so that it will, be flexible if that language doesn't pass. So not a particularly exciting amendment.
You made it sound very exciting, though.
Thank you.
There's a lot of high drama and history in it.
Okay, now I think I'm good to go. Okay, so here we go. So in subsection D of section 319, section 319 is our section that creates the prescribing psychologist authority. Backing out the word the before required fee and inserting in lieu thereof any. And that's it. So if you want me to read the whole subsection, if that is helpful, I'm happy to do that. Or if you're feeling good.
If, I think, because it was Topper who pointed out to me, we already had in the bill one place it said any.
Yes.
And then in a different place it said the.
Yes.
So we're just aligning it with the any that's in, okay.
That's it.
Did anyone want her to read through the language?
How's your lunch?
So reporting it on the floor, all I say is that the committee reviewed the amendment and we'll talk about the result of the vote we're gonna take.
We're just gonna do a straw poll.
Yeah.
And thank you for pointing this out, because we don't want to be the committee that gets stuck on the floor saying, oh, we never heard the amendment. I'm like, let's hear the amendment. You want the star, you're gonna get a gold star. Okay, any questions on this? All those in favor of finding the amendment by the House Ways and Means Committee favorable? 10-02. 9022. 902. And as it's a straw poll, I think that if other members wanted to weigh in on it, they can still weigh in on it. Thank you. Thanks, Katie.
No problem.
It's great seeing you today.
Yeah.
Thanks for visiting us. Okay.
Visit.
So
Thank you.
we're done for the day. I think floor is gonna be very long this evening into the evening. So
Miss Leslie Jones.